My name is Claudio Lombardi. I'm a lecturer at the University of Aberdeen in Scotland. And I was asked to present on the Digital Markets Act. And I decided to take a slightly different view from the usual things that you may have already read somewhere else, or presentations that you may have seen in other venues. And because I would like to focus on the behavioral insights that are embedded, that are included in the Digital Markets Act. So how am I going to go about it? Sorry. There you go. Okay. I would like, first and foremost, I would like to give a very brief introduction to the Digital Market Act for those who don't know what this law is about. Then I would like to focus on, I will just give a couple of hints at what I mean by behavioral law and economics. Then we will delve into the behavioral insights that we can find in the DMA, but also those that we could, and I will argue that the European Commission hasn't reinvented the wheel, hasn't introduced anything so shockingly new, because we could find similar behavioral insights also in competition law, but the new ones have some important differences that we will also discuss in the conclusion. So that's pretty much the plan for today, and I hope I won't bore you to death throughout this presentation. If I do, please do raise your hand and tell me to cut it short if you think I'm going too long. So what is the Digital Markets Act? So according to the European Commission, the Digital Markets Act establishes a set of clearly defined objective criteria, basically to control the to set boundaries to what the gatekeepers, to what the so-called gatekeepers can do, so that the markets remain contestable and fair, right? So the two main objectives of the Digital Markets Act is to achieve contestability and fairness of markets, of certain digital markets. And it does so by, first of all, how did we get here? Well, it now sounds and look like a long history, but it actually all developed in a relatively short time frame, especially for European standards, because the Kremer report and the two impact assessments were published only about 5 years ago now. And they basically triggered, in particular the Kremer report, triggered the formal procedure. First the Kremer report and then the two impact assessments, they triggered the formal decision to pursue the DMA route rather than the new competition tool route. So basically what the European Commission in these two impact assessment did was to submit two reports, where one report was explaining what could have been the adoption of a Digital Markets Act, while the second report said alternatively we could adopt a new competition tool, which is more kind of a sort of market investigation as we see it in the UK. And the Commission opted for the Digital Markets Act. And everything happened again in a relatively short time frame. Why? Why do we have the Digital Markets Act? Many experts said, don't we have already competition law that is true, that literally doesn't pursue contestability and fairness, but basically it does that, because having contestable market means markets where there is competition, and fair competition is, at the end of the day, one of the objectives of competition law. So why not using competition? Standard competition rules? And the answer, it can be found in the DMA, especially if one wants to read in between the lines. And there are many answers to that, but probably the three main reasons are: first, a need for speed and procedural efficiency. So we see throughout the act and also the accompanying documents that the Commission was very much concerned about the duration of competition law procedures, especially in digital markets. These procedures were long, but not as long as many claim, because it's true that we have a couple of cases that were egregiously that took a very long time to decide, about 7 years. But if one wants to look at the average duration of a competition law investigation in digital markets, we are somewhere around 3 years, which is not impossibly long time, but still it was deemed to be, for this kind of markets, a problem. But also address structural problems ex ante, and prevent further distortion or harm by introducing new remedies, because the Commission thought that current competition laws do not allow the Commission to intervene when there are against certain conducts, and thus these needed to be addressed with a specific with a new tool, with the introduction of a new tool. And how does it happen? These in a nutshell. Well, the DMA introduces two new concepts. One is the concept of gatekeeper. The other one is the concept of core platform service. So basically, the Commission has the power to designate, according to a very specific procedure, gatekeepers that provide certain core platform services. And the gatekeeper will be targeted by these, will be bound by the rules in the DMA only for the core platform services that have been designated by the Commission according to these rules. So again, this is a very different approach from traditional antitrust, whereby it's in the case of abuse of dominance, is the abuse of dominance that count, not the type of service that has been provided and whether this was included in a public registry in advance, right? In this case, instead, in the case of the DMA, there has to be first a first stage whereby the Commission designates the gatekeeper and the corresponding core platform services that will be subject to the application of the DMA rules. And once these gatekeepers are designated with their core platform services, then a number of obligations and prohibitions will be applicable to them. In particular, you can find these obligations and prohibitions in Article 5 and 6 and 7. In particular, Article 5 includes a number of prohibitions that are self-executing. These are mostly prohibitions that we've seen already in cases that were decided by the European Commission and the courts in the past. The prohibitions and obligations instead included in Article 6 and 7 are susceptible of being further specified. And many of these are indeed based not on previous case law, not all of them, but some of these are based on economic evidence that was provided to the European Commission in form of academic papers, reports, the impact studies, etc. Now, in particular, Article 5 includes, just to give you an example, Article 5 includes prohibitions such as the prohibition to process personal data, to combine personal data, cross-use, but also MFNs, anti-steering practices, and tying. While it also has 3 obligations. I call them prohibitions and obligations, but you could, this is not how the DMA defines them. In particular, these obligations are allow user-end communications, but also allow user access to user services and provide information to advertisers and publishers. Article 6 instead has a number of prohibitions and obligations as well. For example, data-free writing, prohibitions against defaults and self-preferencing and lock-in that address lock-in, but also obligations regarding, for example, the provision of friend access to data, uninstallation and installation of softwares, and interoperability. Now, and here we come to the actual, to the gist of my presentation. What I would claim is that we find in many of these prohibitions and obligations a number of insights from behavioral science, and in particular behavioral economics. Obviously, if you want, actually, I would be very happy if you stop me while I'm talking, right? So if you have any questions because you think, for example, I'm going too fast and you would like me to focus a little further on one of the slides or on something that I've said, please feel free to do that. I would be very happy. It's not a problem at all. So again, the behavioral insights. So I'm not the first one to observe that. Amelia Fletcher has published a paper exactly on this, on the behavioral insights that can be found in the DMA. She also observes that this is not that the DMA, neither the DMA nor the accompanying documents claim that many of these insights are directly claim that these insights are borrowed from behavioral science and or behavioral economics. However, it is to the trained eye, this information, it looks quite clear. So let's though first define what I mean by behavioral insights, and as compared to the neoclassical view on competition and the economy and law and economics. So the Homo economicus defined by Coasian law and economics, but also neoclassical economics, is a rational individual that only aims at maximizing the efficiency and the utility, his or her own utility, right? So this is what the Homo economicus is. So it maximizes utility, has stable preferences, and accumulates and process an optimal amount of information whenever he or she has to make a decision. Now, however, real people, we know from science, but also from common sense, and this is not an unimportant aspect of this presentation, that not necessarily all the evidence and all the aspects that are inspired by behavioral economics that we find in the European Commission decisions and in the DMA are necessarily borrowed from a literature that we find in, for example, in behavioral science. Some of them are, I argue, are simply common sense statements that are rooted in empirical evidence. So, but anyway, we know that if we want to give proper names to things that we observe in society, real people have bounded rationality, but also bounded with willpower and bounded self-interest. Which means that their rationality is limited, but also the amount of information that they can gather and process, that we can gather and process, is limited. But we also have bounded willpower, not necessarily, even if we have all the information that we need to make the right decision, we want to do that either for problem of bounded willpower or self-interest. And this is something that we have discussed not only in the case of competition law. Actually, in the case of competition law, this has been discussed very rarely, but we have discussed this now for decades. For example, in relation to the Keynesian law and economics versus behavioral economics, where, for example, in the case of bargaining around court orders, I can give you an example. Otherwise, discussing the whole topic would take an hour or so. The Keynesian prediction regarding court orders would bring to the conclusion that if the court enters a judgment, for example, an injunction, then the parties are likely to bargain a different outcome, right? If the reallocation of the entitlements would be more effective than the court judgment itself. And yet we know from empirical evidence, and here there is lots of research, that this is wrong. Parties very often do not negotiate the reallocation of the entitlements, of the court's entitlements, due to a number of issues, in particular the endowment effects, whereby when a person is being given something, there are the famous Muggs experiments that lecturers run in classes. The value that that person gives to that particular object or item is usually higher than the average market value of the same object, of the same good. And on top of that, the winning party usually believes that they have earned it and that is a fair outcome. In fact, injunctions and damages awards usually stick, right? Even when there are low transaction costs. This defeats all the Keynesian theories of law and economics, of standard law and economics. And we have a number of other examples that I don't want to discuss now. However, this problem of examining actual behaviors of actual human beings in the economy and how they respond to certain inputs and or to certain behaviors, it's something that it's true that we have been doing for quite a while now, but is further complicated by online choice architectures. Why? Because online choice architectures can exploit human biases better and with more precision than in-person communication, right? Why? Because online choice architecture actually is a neutral term. So it's not dark patterns, it's not sludge, it's not anything else. It's a neutral term because it's the environment in which people act online. What does it mean? It's basically a website interface is an online choice architecture, right? And so online choice architecture can do a lot of good things for people, for users, because if certain information is presented effectively and is presented fairly, in the sense that all the information that is really needed to the users to make an informed choice if that's presented clearly, then that is a great advantage, right, for the user. However, it can also be misleading. It can be it can take advantage of the biases of the consumers and the internet users, thus leading to exploitation of consumers. Or, for the sake in particular of competition law, this could lead to, for example, steering consumers towards a certain undertaking, and or excluding some undertaking by exploiting certain biases that are that we can find that are innate in human beings, right? Let's give some examples. So the three main categories of we can call malicious or misleading online choice architectures. The three main categories that we have already seen in the literature are dark patterns, sludge, and dark nudges. These describe to some extent very similar deceptive design patterns, but to some extent even overlap. And this is one of the problems in the literature on behavioral insights in online choice architectures, that we do not have a shared vocabulary. So many of these terms very often tend to overlap, or to a certain extent describe very similar behaviors. And we have very little guidance from the courts, because probably judges and courts are also as confused as researchers, so they tend to avoid the use of these terms. But now more and more we are starting to see them. So dark pattern is a user interface that has been carefully crafted to trick users into doing things, right? Sludge instead is when basically you have, sludge is a term introduced by Cass Sunstein, for example, is when the choice architect creates excessive friction, so that it makes it difficult for consumers to get what they want. And we will see, for example, that also here there are some examples in the DMA. What dark nudges is a term coined by a master student, actually, in Italy, an Italian master student. And according to her, the choice architect makes it easy or removes friction for consumer to make inadvertent or ill-considered decisions. So it's kind of the opposite of a sludge, right? Okay, and these are some examples of common deceptive patterns that have been found by other researchers, in particular comparison prevention, confirmed sharing, disguised ads, defaults, drip pricing. You've probably come across several of them, especially now even newspapers largely use this literature, use these names and this vocabulary when they want to describe, in particular, some consumer law infringements. For example, there have been several cases throughout the world about drip pricing in the case of airline tickets, right? So airline tickets have made the headlines in many different countries in the world, because they were showing the actual price only at the very last page, while throughout the very lengthy procedure they would show only a fraction of that price, or even Ticketmaster and other online ticketing services, right? For example, for concerts, they used to do the same. All right, now, but what kind of behavioral insights do we find in the DMA, and are they limited to dark patterns? So let me answer for the second question, the latter one. first. No, they are not limited to dark patterns. They are not limited to sludge. We find insights that are borrowed here and there from a broader literature on behavioral science. And I would divide them into three different categories, three main categories. First are insights that regard the prohibitions that are that apply to gatekeepers. The second category is a category that addresses a neutral choice that is given to that has to be given to the user so that they can choose what they can choose in an informed manner the service that they want to use. And the third category instead is forcing an active choice on the user, because sometimes the neutral choice is not enough to prompt that kind of action from the consumer that might still be biased, in particular due to, for example, its own inertia, right? Don't worry. These three categories, we will examine them in a moment. So if it wasn't 100% clear what I mean by these three categories, I hope it will be in a moment. So let's start with prohibition. We find, for example, a prohibition in Article 5.2 saying that where the consent given for the purposes of the first subparagraph has been refused or withdrawn by the end user, the gatekeeper shall not repeat its request for consent for the same purpose more than once within a period of 1 year. So many of the provisions of the DMA provisions are based on the classic approach of EU consumer law in particular, whereby if the platform obtains the consent from the user, then that particular conduct becomes legal. If there is no consent, the conduct is illegal. Look at the GDPR, for example, but also all the other consumer protection laws that we find in Europe. They are mostly based on users' consent, right? However, here, the DMA goes a step further and says, yeah, I know that you've been playing with these we know perfectly that what you do usually is to bombard users with requests to provide consent for a certain service. And you know that because you know that they are, when they are overwhelmed with all these requests, and this practice is called nagging, at some point they will give you that consent just to make you stop using that pop-up window that is requesting the consent. So this prohibition is based on either on the behavioral literature that explores this particular conduct, nagging, and also provided empirical evidence from social psychology and behavioral economics and whatnot, or just common sense. You know, probably European commissioners were bothered, particularly by these continuous requests, and realized that that actually works, and so they implemented it in the DMA. But we also have the neutral choice kind of category that we can find in particular in Article 6. What do I mean by neutral choice? Look at, for example, Article 6.3, saying the gatekeeper shall allow and technically enable end users to easily uninstall any software application on the operating system of the gatekeeper. But also it says at 6.4 that the gatekeeper shall allow and technically enable installation, in this case, and effective use of third-party software. 6.6 instead says that the gatekeeper shall not restrict technically or otherwise the ability of end users to switch between different softwares, and that 6.13, the termination should be possible without undue difficulty. So all these prohibitions do not really oblige the platform to put the user in front of an actual choice, right? So what they do is only they should not create any friction in the process that leads to a free choice made by the consumer, right, the user. So, which is different from prompting or encouraging a consumer, a user, to make the right choice, right? Or to make a choice in general, right? So in this case, it's neutral. So the behavior that is required is more neutral, is more like do not pose any hindrance to the process that leads to that particular choice. That can be uninstalling a software, or installing something, or terminating a contract, right? The third category instead is these are still other examples, sorry. The other examples are Article 6.5, saying that the gatekeeper shall not treat more favorably in ranking and indexing, and recital 52, saying that ranking should cover all forms of relative prominence. These again are not compelling the digital platform, the gatekeeper, to provide actively consumers and internet users with a specific outcome. What it does, it says that actually to encourage users to do a certain thing, but it actually requires only to present to build the online choice architecture in a way that responds to a fair, in the case of ranking, to a fair ranking of the different indexed websites, and also it presents it in a way that doesn't take advantage of the human bias that tends to be attracted by the information that is presented in a more prominent way. This is called salience, right? And so basically, again, it's not asking digital platforms to encourage consumers to make it to do something, but rather to build the online choice architecture in a fair and clear manner. There are instead also other provisions. We do have 5-10 minutes, right? Other provisions that compel this behavior, in particular through choice screen, to the digital platform, to the gatekeeper. In particular, Article 6.3 again says that the gatekeeper has the obligation to prompt end users at the moment of the user's first use to choose from a list of the main available service providers. This is something that we have seen for the first time, I believe, in the Microsoft 2 case, but and it's something that now we see also in the in the DMA. And as you can see here, the Article 6.3, but also Article 6.4, that says that the gatekeeper shall prompt end users to decide whether they want to set that downloaded software application or software application store as their default. In this case, the gatekeeper has an obligation to prompt an active decision on the side of the user. Why? To fight the so-called status quo bias. Usually, users, as all human beings, tend to settle for what they have already there. And this was, for example, just to prove that there is no we will see in a moment. We will see later that this is nothing new, because that was also the main difference between Microsoft 1 and Microsoft 2 decisions, right? In Microsoft 1, Windows Media Player, the obligation that was imposed on Microsoft was simply to provide a choice between Windows without Windows Media Player and Windows with Windows Media Player. Obviously, no one decided to go for the former. Almost every buyer went for the latter. They realized that there was a problem there, and thus Microsoft 2, the obligation imposed on Microsoft was different. It was to provide a choice screen whereby users had to choose between all different browsers, right? And all these rules, according to Recital 70, cannot be easily circumvented, again, because the DMA utilizes some evidence from the case law and or from behavioral science, because it says that gatekeepers should not engage in behavior that would undermine the effectiveness of the prohibition. And such behaviors includes design used by the gatekeeper, the presentation of end user choices in a non-neutral manner, or using structure, function, or manner of operation of a user interface to subvert or impair user autonomy, decision-making, or choice. Here, the language is very much the language of behavioral science and behavioral economics. Now, again, if they did that on purpose or just because they observed these issues throughout their enforcement experience in this market, something that, to be honest, I don't know, but it's clear there is a clear trace of it here, in particular in Recital 70. And you find that this approach to the effectiveness principle that has been noticed in particular by Fletcher in a paper is you can find these in articles 1 and 8.1 and 8.2, and also article 6 and 13. So basically, that they want to make sure that these prohibitions are not circumvented, and so that they are effectively applied in these cases. Now, is this really everything new? Is all this behavioral science and behavioral economics wisdom used for the first time in the DMA? Not at all. I don't believe so, at least. We've seen behavioral economics, or at least empirical evidence that at the end of the day forms the bulk of behavioral economics, for example, in particular in Article 102 infringement decisions, in all the three main stages of an Article 102 prohibition decision, we see that in market definition, where, for example, we see it in the Article 82, now 102 guidance, a paragraph 50 saying that demand substitution is addressing the demand substitution notice, saying that customer choices may be subject to behavioral biases, such as a tendency to choose the default option. So that is something that already the guidance was observing 15 years ago, and also Article 54, addressing instead a hypothetical substitution, makes the same observation. But also in the stage of dominance, we see that, for example, the European Commission, differently from other antitrust authorities, for example, in the US, considers several factors when it analyzes the barriers to entry and expansion, but also the entry, the likely of and the effective constraints in a specific market. And we find again these in the guidance. In particular, what does it take into consideration? Consumer biases. So it's not just what the theoretical consumer would do that is applied, in particular, for example, in the SNP test, but is what the actual consumer would do. Would they switch to a competitor? Yes or no, right? So this obviously has this evidence is very often, for example, relies on methods that the European Commission as well says that are not bulletproof. So has to balance between the different methods utilized. For example, qualitative research, interviews. There are other biases that are very well known to qualitative researchers, like framing and other problems. But this is definitely evidence that is always that has always been considered by the European Commission, but also at the stage of the final stage of finding an abuse. You see that, for example, in predatory pricing cases, where the recoupment of losses does not constitute a necessary precondition. Why? Because the courts admitted that it's possible that a dominant undertaking engages in irrational behavior, just for the sake of quiet life, for example, right? But also in Microsoft, we have seen that I explained the case a moment ago, and why is among the cases that I'm discussing, where, for example, in Microsoft One, the Commission considered the psychological bundling between two softwares. In that case, they could be unbundled. In theory. In practice, though, the status quo bias usually prevented the average consumer from unbundling those two softwares. And the same in Microsoft too. Now, to conclude, I think that I'm on time, right? Surprisingly, yeah. Okay. So to conclude, this is all the observations that, and by the way, on these cases, about 10 years ago, I haven't written it here. I'm so sorry. Okay, so about 10 years ago, Nicolas Petit and a co-author, I can't remember now who was the co-author, they published a paper examining exactly this line of this case law that utilized behavioral insights. So again, also from that point of view, we had already some literature observing these in the past. So long story short, what I wanted, the point that I wanted to make today is that both the case law that I mentioned, as well as many other cases, for example, we didn't explore the Google cases that more directly use behavioral economics in the decision. and some other national cases. For example, in the UK, there is a very good report published by Amelia Fletchers and others that includes also a long list of cases that have been decided by the CMA, for example, that use these behavioral science, or better, insights from behavioral science. But so what I want, the point that I wanted to make is that these observations, more than being rooted in behavioral economics and behavioral science and research, are mostly rooted in empirical evidence, and and probably the de facto implementation of these behavioral insights that come from this evidence that has been gathered throughout the years. But that online choice architectures pose new challenges, which are in particular at the intersection between manipulation, precision, and steering. So that very often it will be difficult to determine to what extent a certain conduct is effective, using the words of the DMA, into, for example, steering consumers towards a different service, in the sense that either persuades them or manipulates them in a way that these consumers are actually steered towards a different service. And when we will have to grapple with that, then most likely courts and the European Commission will have to delve into this new evidence from behavioral science, because they will. So the DMA, one good thing is that it doesn't require manipulation per se. So as defined by the courts, in particular in consumer and contract law. So it doesn't really talk about manipulation of consumer or even coercion of consumers. But there are concepts that will have to be defined according to the weight of this persuasion into the decision-making mechanisms of the average users, right? So most likely they will have to anyway look into this literature that is growing, that is experimenting more and more, and is providing new data. Okay, thank you very much, everyone, and hopefully it was clear. Yeah, thank you.